I'm Patrick Giacomo, an attorney with the Institute for Justice, working on our project on immunity and accountability. With police reform in the national debate today, everyone's talking about qualified immunity. On his show last night, Tucker Carlson strongly defended the doctrine of qualified immunity and said ending qualified immunity would end law enforcement in this country. Here are 6 things Tucker gets wrong.
Under current law, police officers in this country benefit from something that's called qualified immunity.
Just to clarify, qualified immunity is not a doctrine that applies only to police. It shields all government officials, state, local, and federal, when they violate constitutional rights.
Qualified immunity means that cops can't be personally sued when they accidentally violate people's rights while conducting their duties. They can be sued personally when they do it intentionally, and they often are.
Actually, qualified immunity doesn't consider whether an officer's actions are accidental or intentional. For example, a case out of California recently applied qualified immunity to police who were accused of having intentionally stolen more than $200,000.
In other words, police officers are not above the law. They never have been. Cops who commit crimes can be punished, including in civil court. Cops who make lesser mistakes can be disciplined, suspended, or fired, and they often are. That's the system we have now. It works pretty well. Civil immunity, by the way, has precisely nothing to do with anything that happened in the George Floyd case. Just in case you're wondering, that cop is in jail.
It's true that qualified immunity doesn't apply in criminal cases, but the reason qualified immunity hasn't come up in the George Floyd story yet is that his family hasn't had a chance to file their civil constitutional lawsuit. When they do, the officer who killed George Floyd will be able to claim qualified immunity, and it won't matter whether he acted intentionally or has been convicted of murder.
Qualified immunity has worked so well because police officers, maybe more than anyone else in our society, must make difficult split-second decisions on the job, and a lot. They do it constantly, whether to arrest someone, whether to conduct a search, whether to use force against a suspect. Sometimes actions they sincerely and reasonably believe are legal are found later by courts to be unconstitutional. Sometimes the very laws they enforce are struck down. That's not their fault, obviously.
Qualified immunity isn't concerned with split-second decision-making. There are many instances where qualified immunity has been applied where the government officials had more than enough time to think about what was happening. For instance, a case out of Texas applied qualified immunity to members of the Texas Medical Board who searched an officer's confidential medical records without a warrant. There was no split-second decision-making in that case. Either way, if split-second decision-making is what you're concerned about, the Constitution already protects that under the Fourth Amendment.
But without qualified immunity, police could be sued for that personally. They could be bankrupted. They could lose their homes.
Research from UCLA law professor Joanna Schwartz shows that when police are actually found guilty of violating someone's constitutional rights and damages are awarded, they almost never pay any of them. Instead, their government employers indemnify 99.98% of all damages awarded against them. So the concept that ending qualified immunity would put police in the poorhouse has no basis in reality.
That's unfair. It would also end law enforcement. No one would serve as a police officer.
The Supreme Court created a weaker version of qualified immunity in 1967, which later morphed into the modern doctrine that we have today in 1982. Before 1967, American cities and states had no trouble attracting great police officers who were able to balance their duties under the Constitution with their duties to protect and serve the communities in which they worked. The Institute for Justice is committed to government accountability. If citizens must follow the law, the government must follow the Constitution. If you'd like to know more, please check out ij.org.